This is Barry Zalma speaking for Claim School Incorporated's Zalma's Insurance Fraud Letter for July 1, 2023, Volume 27, Issue Number 13, in the Source for Insurance Fraud Professionals. From my blog, this, the 13th issue of the 27th year of publication of Zalma's Insurance Fraud Letter, provides multiple articles on how to deal with insurance fraud in the United States. The issue begins with an article entitled Fraud in Inception is Grounds for Restitution, and there is no restitution available from a defrauded insurer. The article begins with Esurance Property and Casualty Insurance Company appealing the trial court's order granting summary disposition in favor of Nationwide Mutual Fire Insurance Company and denying Esurance request for summary disposition. In Nationwide v. Esurance, a June 15, 2023 decision of the Court of Appeals of Michigan, Esurance alleged its insured defrauded it when it acquired the policy, and it was entitled to rescind the policy regardless of the trial court's attempt to balance the equities. You can read the full article at the link to the article in the blog. Then there is more on McClenny Moseley Associates, ZIFL's 9th installment on the saga of McClenny Moseley Associates and its problems with the federal courts in the state of Louisiana and what appears to be an effort to profit from what some magistrate and district judges indicate may be criminal conduct to profit from insurance claims relating to hurricane damage to the property of the public of the state of Louisiana. The first note deals with a June 14, 2023 order from U.S. Magistrate Judge Michael North, who held a hearing to advise insurers on how to handle thousands of Hurricane Ida claims affected by the alleged fraud by McClenny Moseley Associates. It was standing room only at the hearing, with more than 200 lawyers in court, including one who actually fainted. You can read the full text at the link in the blog post and various other problems going on in the month of June with regard to MMA. Then there's an article entitled Ethics in the Public Insurance Adjuster, where we relate an example of a public insurance adjuster and the lawyer who failed to follow the requirements set out by the National Association of Public Insurance Adjusters. Both represented the same client involved in a claim that resulted from the 1994 Northridge, California earthquake. The earthquake caused billions of dollars in damage across Southern California and drew lawyers and public adjusters seeking large fees like vultures flying over a dead antelope. As a result of the disaster, investigation by insurers was limited because of the extent of losses caused by the earthquake and the need to rapidly serve the needs of the insureds. Many unnecessary and spurious suits were filed, insurance fraud was rampant, and insurers paid rather than fight because there were inadequate staff available to deal with fraud in governmental agencies who were threatening insurers with major fines if they did not pay quickly. You can read the full article and the full issue at the link in the blog post. Then there is good news from the Coalition Against Insurance Fraud, including a story about when faced with a fraud conviction, a woman couldn't stop herself from doing it again, and Tania Burma, who had been court-ordered not to obtain employment or a volunteer role involving financial authority, did so anyway and got convicted again. Then there is an article about an order limiting cross-examination that is fair and appropriate. In People versus Renee, Louise, Witt, a June 5, 2023 decision of the California Court of Appeals, a jury convicted Renee Louise Witt of committing 7 counts of medical insurance fraud in violation of Penal Code Section 550. The trial court suspended imposition of sentence and placed Witt on 2 years of formal probation and ordered her to serve 364 days in jail, and yet she appealed, only to gather the ire of the court. Then there's a list of health insurance fraud convictions, starting with the conviction of a Gloucester County man who admitted to health care fraud. Christopher Gualtieri of Franklinville, New Jersey, pleaded guilty before U.S. District Judge Roger B. Kugler to 1 count of an indictment charging him with conspiracy to commit health care and mail fraud, and 1 count charging him with obtaining oxycodone through fraud. Gualtieri, a Gloucester County, New Jersey man, on June 12, 2023, admitted defrauding his employer's health insurance plan out of more than $4 million by submitting fraudulent claims for medically unnecessary compounded medication. You can read all of the convictions, dozens of the convictions, in addition to that of Mr. Gualtieri. Then there's the article on other fraud convictions, starting with a case where Clegg Gifford shunned over $7 million worth of fraudulent claims. An insurance broker, Clegg Gifford, had successfully identified and avoided more than £7 million worth of fraudulent motor trade claims over a period of 4 years with the help of the counter-fraud team at law firm DAC Beechcroft. You can read about that conviction and the dozens more at the link in the blog post. This video was adapted from my blog, Zalma on Insurance, and from Zalma's Insurance Fraud Letter for July 1, 2023. The blog is available to anyone for free who links and clicks on the URL zalma.com/blog. It's also available as a video on youtube.com and on rumble.com. And if you watch the video, I'd appreciate it if you click on the like button or the thumbs up button on Rumble. And I'd appreciate it also if you found the information useful, that you please advise your friends and colleagues so that they can also subscribe to the newsletter, the blog, and or the videos. Thank you for your attention.